Thank you, Dawn, and to the organisers of this very interesting conference for inviting me to speak. And I must say, as I look around the room, this is a formidable prospect because they're a very interesting gathering of people from all sorts of sections of our society, both in respect to the past and the present. So this is a very challenging issue, but here are my thoughts from the perspective of someone who has been called a poacher turned gamekeeper, who has spent most of my professional life representing those who found themselves, perhaps on the wrong side of the state, now to a position where I represent the state in my capacity as Director of Public Prosecutions. But I suppose I should begin with reflecting a little bit on what we mean by the past. And I think perhaps in the context in which we find ourselves, which is within the political entity known as Northern Ireland, which has existed since 1922. And of course, I need not remind anyone of our troubled history throughout the existence of this political entity. And I suppose most significantly in the last 25 years, between 1969 and the IRA ceasefire of 1994, which ultimately led to the Loyalist ceasefires and eventually the Good Friday Agreement. But that conflict in it, that aspect of I think what must undoubtedly be the history of a state, or if that's perhaps too grand a term, of a political model which has been in conflict since its inception, was the most intense, and it led to some 3,500 deaths, with many more being maimed and injured. And thinking about that, that means that many, many thousands of families in this jurisdiction, which is a population of only, I'm told now, 1.7 million, have been directly touched by this conflict. In fact, a recent survey has suggested that some 43% of the population were either injured or had a close friend or relative killed or injured in the violence that was perpetrated on the people of this part of the island of Ireland. And of course, there is another dimension to this conflict beyond assessment of the damage that was done to people in terms of physical harm. Communities were driven apart, neighbours became estranged from neighbours, and conflict arose even within families. Many hundreds of young people who, it must be recognised, in a normal society would never have found themselves on the wrong side of the law, ended up in prison, some for many years. Thankfully, by 1998, the people of Northern Ireland, through their elected representatives, reached an agreement on a formula of governance that would allow us, with some exceptions, to live in relative peace. In doing so, however, deep divisions had to be set aside and compromises made. In order for this to be achieved, it is arguable that the deeds of the past on all sides simply could not be confronted and had to be set to one side. We are now 15 years on, however, from the Good Friday Agreement, and the issue of how we deal with the past remains very live. However, I stand here now as Director of Public Prosecutions, and as such, I am a Minister of Criminal Justice. And if the essence of criminal justice is acquitting the innocent and convicting the guilty, then arguably my role is a very clear one. I, along with my colleagues in the PPS, have to ensure that prosecutions are dealt with fairly and that the rights of the defendant are recognised. It is important to attempt to deal with cases efficiently and expeditiously and keep in mind the rights of victims and witnesses. Above all, however, it is imperative that a prosecutor seeks to apply the rule of law evenly. In order to do so, I believe it is imperative that the prosecution service maintains a degree of independence from both the investigators and indeed, to some extent, from the state itself. Dealing first with the investigators, the prosecuting agency must be sufficiently independent and robust to make a judgment that the fruits of an investigation are either evidentially sufficient to bring about a conviction, or, in rare cases, the public interest would not be best served by pursuing a prosecution, even where the evidence might suggest that it would otherwise be successful. Such a degree of independence acts as a brake against potential abuses of the investigative powers, which by necessity are often intrusive and far-reaching. At the same time, however, prosecutors must be open to exploring ways in which we can work together with the investigative agencies to increase efficiency without compromising our independence. Independence from the state, of course, begs the question, what is the state? I suppose in coming to the personal decision to seek to become a prosecutor, as I said earlier, having been a lawyer representing those who found themselves for one reason or another on the wrong side of the state, I had to give this some very careful thought. There's more to the state, of course, than simply the question of where does sovereign power lie. Since the people of Ireland voted overwhelmingly north and south to endorse the proposed model of government contained within the Good Friday Agreement, it can no longer be said that there is a significant part of the population within the Northern Ireland jurisdiction which no longer wishes to be governed within the political structures we now enjoy. Doubtless, many people may be less than satisfied with the current arrangements, the limitations of which are becoming ever more apparent. But nobody can now say that there isn't an overwhelming degree of political consensus, at least on the question of by whom all should be governed, at least for now. So when the PPS prosecutes, it does so, in my view, on behalf of the people of the jurisdiction of Northern Ireland, with the consent of the vast majority of the people, and as such, it is a totally apolitical function. We, of course, must be accountable to the people through the media and through the political structures. While there may be some debate about the best format for achieving such accountability, I don't think anybody is in any doubt that our function is and should be performed free from political interference, however that might be achieved. And of course, the question of the public interest is also difficult to define. This is not necessarily in the interests of the public, which are apt to change from group to group and from time to time. Prosecutors have to take a measured view of the greater interest of the administration of justice in exercising this responsibility. In the short time during which I have been Director of Public Prosecutions, I have personally only determined not to pursue a prosecution where the evidential test was met on one occasion, and this was not a historical case. It is a responsibility that weighs very heavily with me and one which I exercise very carefully. Some public interest decisions may perhaps be explained and others simply cannot. And in that regard, I am very aware that the state, as in you, the people of Northern Ireland, repose in me a very great trust. So just how do we exercise this responsibility within the PPS? All decisions as to prosecutions are subject to rigorous scrutiny of the evidence and the exercise of the quasi-judicial function in the application of the test for prosecution, which is set out in the Code for Prosecutors. That test prescribes that a prosecution can only be commenced when the two-stage test for prosecution is met. Firstly, that there is sufficient evidence to afford a reasonable prospect of a conviction, and secondly, that prosecution is in the public interest. Our Code of Ethics, which has been guided by international standards and best practice, embeds human rights standards and requires that the prosecutor must at all times act in a way which is compatible with the Human Rights Act in 1998, the European Convention of Human Rights, and all other relevant international conventions and declarations. However, the adversarial trial system and the duties placed upon the prosecutor have an undeniable influence on the way in which the prosecutor might be perceived by the victim, defendant, the public, and particularly in the way in which our work is reported upon by the media. It is important that the role of a prosecutor and the duties and constraints placed upon us are properly understood by all to ensure that unrealistic expectations are not created, disappointment or distress caused, and that what I might call misunderstandings are avoided. In the case of Boucher, in the Supreme Court of Canada, Rand J. expressed it very eloquently when he said the following: "It cannot be overemphasized that the purpose of a criminal prosecution is not to obtain a conviction. It is to lay before a jury what the Crown considers to be credible evidence of what is alleged to be a crime. Counsel have a duty to see that all available legal proof of the facts is presented. It should be done firmly and pressed to its legitimate strength, but it must also be done fairly. The role of prosecutor excludes any notion of winning or losing. Its function is a matter of public duty, and there can be none charged with greater personal responsibility. It is to be efficiently performed with an ingrained sense of the dignity, the seriousness and the justness of the judicial proceedings. And the Privy Council said in another case that the duties of the prosecutor was as follows: it is not to obtain a conviction at all costs, but to act as a minister of justice. On the issue of the extent to which we, as prosecutors, represent victims, I would say the following. And I take this from the House of Commons Justice Committee report into the Crown Prosecution Service, that the prosecutor's role in relation to victims also seems to be generally misunderstood. The prosecutor is not able to be an advocate for the victim in the way that the defence counsel is for the defendant. Yet government proclamations that the prosecutor is the champion of victims' rights may falsely give this impression. Much of the prosecutor's work by its nature serves the needs of the victims, and we should strive for a better service to victims, but there needs to be a better understanding of what is possible for the prosecutor to do in relation to victims. I think it is important that when we consider the prosecutor's duty in respect to the past, that we bear that in mind. In terms of the human rights aspect of the prosecutor, our role must be examined in the context of the jurisprudence of the European Court of Human Rights, in which one case it was said, it is true that Article 6 does not explicitly require the interests of witnesses in general and those of victims called upon to testify to be taken into consideration. However, their life, liberty or security of person may be at stake. Against this background, principles of fair trial also require that in appropriate cases, the interests of the defence are balanced against those of witnesses or victims called upon to testify. So, such is the balancing act that prosecutors must perform between the interests of victims, yet not making those so central to our function that an imbalance is created in the conduct of our role as ministers for justice, yet at the same time attempting to present the best evidence before a court in appropriate circumstances. These standards will be applied by the prosecution service irrespective of the nature of the criminal offence, whether it be political or non-political, arguably, and irrespective of the time at which the offence is alleged to have been committed. In other words, we make no distinction between the present and the past in the context of the application of this test. That is not to say, however, that there aren't difficulties which must be recognised when asked to take prosecutorial decisions concerning the past. A prosecutor is only as good as the material provided to him or her upon which to make the prosecutorial decision. The older the case, the more likely it is that the evidence will be impaired and incomplete. The policing of the past is arguably much more difficult than the policing of the present and requires significant commitment and additional resources in the gathering of evidence. The passage of time in practical terms creates many difficulties. For example, some defendants and witnesses may be deceased or infirm. Memories are impaired and records may be destroyed or missing. Electronic evidence that might otherwise be available, such as CCTV or phone records, may not be accessible. There may be limitations in the DNA evidence because of the passage of time. But then again, we have other developments in the law we can seek to deploy, such as significant changes in the rules of evidence in respect of admissibility of, for example, bad character and hearsay, the introduction of special measures to assist witnesses in giving of evidence, legislation in respect of assisting offenders, and the changes in the law of double jeopardy. Within the parameters of all of these changes and challenges, it remains the case that offences will be prosecuted when the test for prosecution is met. As I've said above, this is a conflict, the recent manifestation of which lasted over 25 years and which touched many thousands of people. It is for those who we have elected to represent us at the political table to make some very important decisions as to how we address our violent and lawless past. In South Africa, for example, Kader Asmal, one of the key architects of the Truth and Reconciliation Commission, argued for a process that would not insist on criminal prosecutions. In doing so, he acknowledged the following: "We sacrifice justice for truth so as to consolidate democracy, to close a chapter of the past and to avoid confrontation." Clearly then, in South Africa, a political decision was taken to reinterpret justice as a search for the truth rather than one for retribution. However, this has not necessarily been universally welcomed in South Africa. Some of the victims of that conflict sought to overturn the setting up of the Truth and Reconciliation Commission in their Supreme Court, but without success. The decision to grant amnesty and somehow or another, the copy I've been given is incomplete, but I think I can remember what was it. The decision to grant amnesty in South Africa, as I said, wasn't universally welcomed. But what I'm getting at here is that is the decision which our politicians must take. What we decided to do 15 years ago when the Good Friday Agreement was introduced was park the issue of how we deal with the past in order to assist in reaching an essential political accommodation to ensure that the violence of the recent past was never repeated. And I think 15 years on from the Good Friday Agreement, we are now at a point where we must decide if that was the correct decision and whether or not society wants to address the issue in that way or not. But what I have to say from my perspective as a prosecutor is that is not my role in all of this. My role as a prosecutor is to seek to bring prosecutions where the evidence is available, and that is what I will continue to do unless or until society takes a different view. But what I would say about the prosecuting of the past is that if the past is going to be prosecuted, and if the prosecution service is going to be expected to deliver prosecutions in respect of events in the past, it needs to be properly investigated and properly resourced. So I think society has got to make a choice. Either it decides now to go down the road, the very difficult road of determining that we are going to forgo the prosecution, the investigation and prosecution of the past in favour of embedding the political institutions or the peace process, or between that and deciding whether or not the peace process is best served by continuing to prosecute the past. If it's going to be the latter, then I think there needs to be a very clear investigative structure established with very clear lines of definition and with significant resources. And if that is going to be done, it needs to have a terms of reference which will cover all criminality from all sides. And in respect of prosecutions then, the prosecutorial aspect of this will have to be significantly resourced as well. I think that has not yet happened. We do not get a large number of files from the historical investigators. We have brought some quite significant prosecutions when those files that have been sent to us have produced enough evidence. But I think perhaps the time has come when our society should reflect on how we're going to address this issue, because we appear to be drifting along at the moment in a vacuum of some uncertainty. But certainly, as the Director of Public Prosecutions, I don't think it is my role to deny any victim of an injustice the delivery of true justice to that person or his or her family. As the Director of Public Prosecutions, that is what I must strive to do in the current circumstances. But that's not to recognise that there aren't difficulties. So I think that's really what I wanted to say. Thank you.